Good evening and welcome to Law and Order, brought to you exclusively by Channel I. Tonight we're going to take on the topic of vertical living. What is vertical living? When we do a drive down Gaul Road or even Marine Drive or anywhere in Colombo for that matter, we see that the skyline of Colombo is changing drastically. There are high-rise buildings coming up, apartment complexes by the dozens coming up. Every month there seems to be more and more being added to the skyline of Colombo. But with this, there are various legal questions that crop up for those who are developing these apartment complexes and for those who propose to become owners of some of these apartments. And to take on this very, very tricky issue is an expert in the field, that is none other than Ms. Ajitha Edrimanna. Thank you so much, madam, for taking time off your busy schedule to be with us tonight on the show.
Thank you for inviting me.
It's a pleasure. It's an honor to have you here. Ms. Edrimanna has authored a book, Understanding the Concept of Condominiums, which in itself is a handbook used by most lawyers, and she is not, she needs no introduction in that sense. She counts more than 33 years in the profession, and she is more than competent to take on this concept and this pressing issue that faces Sri Lanka right now. Just to start off with, let's go down to the nitty-gritties. What is a condominium?
Condominium, first of all, I'd like to tell you that it's different from owning a block of land. In our country, it's Roman Dutch law that applies to land. And in terms of Roman Dutch law, any person who owns land also owns anything attached to that land. So it's kind of a vertical ownership, right from the bowels of the earth up to the heavens above. But you can't have that kind of ownership if for condominium properties. You need to move away from vertical ownership to give title to a unit on a horizontal layer of a building. So to do that, we had to move away from Roman Dutch law, and how we did that was by enacting a statute. Yes. That's the apartment ownership law.
Yes.
So to create a condominium property, you need to register the building in terms of the apartment ownership law provisions.
Right. So what essentially would be the difference between owning a plot of land or a house in the orthodox sense of owning land to owning an apartment parcel or an apartment in a condominium?
Now, in the case of owning a house, a owner of a house can do anything he or she wants. That means subject to certain legal restrictions. But when you own a condominium unit, there are certain rules and regulations. These are called bylaws, because you are living in a different community. You owe certain obligations to the other unit owner because units are attached to each other. Then you are using an area called common elements which do not come within any of the units, like corridors, swimming pools, playgrounds, areas like that, which you are sharing with the other unit owners. So you have to abide by these bylaws. There are certain statutory bylaws as given by under the apartment ownership law. But apart from that, developers, when they create condominium properties, they also lay down rules and regulations, which of course each unit owner has to observe if they want to live in a harmonious environment.
Now, ma'am, if I want to buy a piece of land, I simply identify this land that I want to buy, and then I meet the owner, the vendor, and thereafter we discuss, we negotiate the terms, and if I am agreeable to pay the consideration that he wants for the sale of this, then it's a matter of approaching our lawyers. The lawyers draw up the transfer deed, we sign, and then thereafter ownership is mine. After it is, of course, it has to be registered in the land registry and notarized. Is that the same thing that happens when it comes to apartment ownership, or are there any differences?
The same, only to the extent that you have to acquire title by executing a deed of transfer.
Yes.
Right? But it's different in other ways. Now, in our country, a developer would develop a block of land, construct a building, then subdivide it in accordance with the condominium plan, then register the condominium plan along with a deed of declaration, which results in a condominium property
Yes.
under the apartment ownership law.
Yes.
Now, when a developer wants to sell a unit, what they would do is, you have seen lots of brochures, beautiful websites,
Yes.
and they promote their units, but they, even though they have to register the provisional condominium plan, in many instances the developers don't do that. They show a sketch of the unit and describe the environment and start pre-selling. That is,
I see.
even before the building construction commences, they start pre-selling.
Yes.
Now, I want to tell you, in our country, we don't have any mandatory legal provisions for pre-selling.
Oh, I see.
In the Apartment Ownership Act, that is the latest 39 of 2003 amendment, they refer to provisional condominium properties.
Mhm.
But nowhere does it say that it is mandatory for a developer to register a provisional condominium property and then
Okay.
start pre-selling.
Okay.
So what we see is lots of buildings, because developers want to raise funds for the purpose of completing construction. They need to raise loans from financing institutions, so they are in a hurry to start selling. So actually, in other countries, they have to abide by lots of rules and regulations before they start pre-selling. Like, for example, in United States and other development countries, you have to issue a disclosure statement.
Mhm.
That is mandatory, like a prospectus before you start issuing shares in a company.
Right.
And this disclosure statement is registered with the authority, but we don't have anything like that. So we have these buyers who really don't know anything about condominium law or anything about the building other than that it is in a good location. So they are attracted to the location, attracted to the furniture and fittings and everything that is offered, may be attracted by, sometimes these developers are well known, and they purchase units. But then as time goes on, they also face problems, because as I told you, this provisional condominium registration has not been made mandatory.
So what you're saying, ma'am, is that when these developers start pre-selling, the purchaser, there is nothing to guarantee that guarantee what the purchaser will actually end up with, the end product. Is that what you're saying?
But what I want to emphasize is, now for pre-selling, you don't go ahead and do the deed of transfer. The developer offers a sales agreement to the purchaser.
Yes.
So that sales agreement carries lots of terms and conditions.
Yes.
It's always one-sided.
I see.
It's in favor of the developer, because developer wants to complete the project without any harassment. In one way, it's true, because developers put in a lot of money, and it's major projects. High-rise buildings are huge projects. But on the other hand, you cannot say that it should always be favorable for developers.
Yeah.
If you want a conducive environment for this kind of building construction to progress, then you have to look after the interests of
The
purchasers, because they are the weak party.
Correct.
So when sales agreements are given and different types of clauses are incorporated, and the purchaser, some purchasers don't come to lawyers, they
Just
for
sign.
various reasons they would sign. Then later on, when in most cases the projects do not complete on the due date, and in some sales agreements the estimated completion date is also not given.
Stated.
So sometimes there are delays, and then suddenly the purchaser finds his money is tied up, and what he expected has not been realized. So there are problems. Now we have authority, Condominium Management Authority, which is the regulator for condominium properties. Now in such instances, there are lots of things that an authority can do. For example, in Thailand, developers cannot just issue sales agreements. In Thailand, the law requires that there should be certain standard clauses
In the sales
agreement. Like defects liability period should be minimum of 12 months, and they cannot have clauses which are truly against the purchaser. So there are various things that one can do as a regulator. Maybe have regulations that the standard sales agreement should have this type of clauses in order to protect the purchaser.
Now, ma'am, if for the benefit of those of the viewers who may be considering purchasing an apartment, and they go and meet a developer, and then the developer now says that they have to make a down payment, which is a percentage of the entire consideration, and there at that point they have to enter into a sales agreement. What precautions would you advise such potential buyers to be wary of? What should they watch out for?
Yeah, that's a very good question. Actually, this sales agreement, the clauses would be comprehensible only by a lawyer. I'm not trying to promote the legal provision, but what I'm trying to say is people should not just put down their money. Signature. They must, if they can understand, go through all the clauses. And if they don't know anything, if they do not understand, at least check with the developer. Because there are certain very important clauses that you should not just put down your signature for. Like as I told you, the defects liability period. And also the fact that they must get the certificate of conformity before the commencement of the defects liability period. Then the developers try to limit their liability, right? It's normal because developers can't be liable for everything. But they should not try to limit their liability in the instances of their own misconduct and negligence. So if you find a clause where it gives like total clearance for a developer, you should say, no, I am not willing to sign this. And then the description of the land, description of your unit, what facilities and amenities are given, do you have to pay more for those, what kind of like management fee would I have to pay, service charge. There are lots of questions that one should ask. Then over and above that, this is something that a purchaser would not know. Purchaser must find out whether the developer has proper clear title to that land.
Yes.
Okay.
Yes.
So for that, of course, they'll have to go and seek advice from a lawyer to do a title search. And most purchasers, if they can't raise the money, they have to go to a bank to raise a loan. So then, of course, the bank would ask for the title up to 30 years with extracts. And also, if the title is not clear, just because the building is located at a good place, convenient to schools, I don't think a person should rush in and part with their hard-earned money. They must then at least check with the bank or tell the developer, look, we are not happy with this title. You should at least get a title insurance.
Yes.
So there are so many things that one should observe and be mindful before signing a sales agreement.
Thank you, ma'am. Now, you mentioned that there are instances where the developer does not have clear title. We have also seen instances where it is on lease, it's been leased to the developer. Now, in those circumstances, the potential buyer, what kind of rights would they be able to get if the property is not even owned by the developer?
Actually, that wouldn't be a hindrance because in case of government owned land which are given to reputed developers, the government gives the developer a 99-year lease over the land. So if the developer and the government together execute the deed of transfer, like Board of Investment representing the government may own a block of land and would give it to a developer on a 99-year lease, then the BOI as well as the private entity, the developer, would execute the deed of transfer. And in the case of the sales agreement too, the BOI or power of attorney holder representing the BOI would sign the sales agreement along with the developer, then it would be okay.
Okay, so in those circumstances, it's not necessary for the developer to have outright title.
No, it's not necessary as long as both parties get together
and sign. Now, ma'am, you also spoke of certificate of conformity. Now, there are instances where even after the sales agreement has been entered into, first and foremost, for the benefit of our viewers, could you just tell us what a certificate of conformity is?
Yeah. Now, before a developer starts constructing a multi-story building, they have to get a development permit. For that, they have to give a building plan, obtain approval from the relevant authority. It can be the, in the case of Colombo, CMC, UDA, or outstation, there are branches of the UDA. So they have to get approval for the development plan and then a development permit. Now what that development permit says is that they have to construct the building in accordance with the approved plan. Now once the building is completed, the certificate of conformity is given only if that building has been constructed and completed in accordance with the approved building plan.
Right.
So that is what is meant by a certificate of conformity.
Right. So, so you would advise our viewers to ensure that this certificate of conformity has been issued prior to them entering into any form of transaction with the developer. Is that what you are saying?
The certificate of conformity can be given only at the end of completion, you know. So at the time of sales agreements, there is no COC. So, but at that stage, the prospective purchaser must ask the developer whether they have a development permit.
Development permit.
In most cases, they hold only a preliminary clearance. That is not good enough to part with several million rupees.
Yes.
And also there are various other things that one should check, which I do not think a purchaser would be able to check on his own. Like if the building is close to the ocean, then the developer should have a coast conservation certificate allowing, you know, those things are looked into. Then the certificate of ownership from the Pradesh Sabha, street line clearance, building line clearance, lots of documents have to be obtained by a developer. So those things necessarily will be checked by the purchaser's lawyer. Now a purchaser must necessarily ask the developer or through the lawyer find out whether the developer holds all these documents. That's important. And at the time of executing the deed of transfer, actually the COC is absolutely necessary to register the condominium property. A lawyer would get not only the COC, they have to annex various other documents like a certificate from the structural engineer, ensuring that the building has been completed in accordance with the approved plan, and so many other documents which are annexed to the deed of declaration signed by the developer, submitted to for registration to the land registry, or where the registration of documents ordinance does not apply, there are title registries. So there are forms for that kind of registration. Anyway, once those things are submitted, then the building is completed as a registered condominium property. So you really do not need to ask whether certificate of conformity has been issued, because a developer has to give you a copy of the condominium plan before you do the deed of transfer, and in that condominium plan and a copy of the deed of declaration, all these relevant attachments will be there. So you can check from those documents whether the COC has been issued.
Right. So just coming back to how we started this discussion, madam, first and foremost, if someone wishes to purchase a condominium parcel or an apartment, they would meet the developer and at that point enter into a sales agreement.
Correct, yes.
Then thereafter, at what point would the deed of declaration be entered into?
Yeah. So now this process of completing would take maybe 2 years or even more. So once the entire building is completed, the developer applies for the COC and the authority comes and checks the building that is issued. Then only can the developer submit the deed of declaration under his signature along with all these other documents to the land registry. So when the registration process also takes about 1 to 2 months. After that, the entire building is completed, and at the land registry, a folio is open for each and every unit. Only at that stage can one do a deed of transfer.
Right. So it has to follow this sequence in order to finally culminate with you getting title, proper title to that apartment.
Yes, exactly. Yeah.
Okay, ma'am. Now, in instances where, say for example, something that you touched on earlier, we don't have much time, but I don't want to neglect discussing this point as well. But when a sales agreement is entered into, and just taking an example from what you mentioned, say that the completion period is 2 years, but the developer takes longer. What are the remedies available to a purchaser in those circumstances when the developer has clearly violated a term of the agreement?
Yeah, this is quite a common occurrence.
Yes.
And that's why I say in the sales agreement one should check whether the estimated completion date is given. At least, and sometimes in the sales agreement the developer would say that this date may be extended due to reasons beyond the developer's control. So there can be reasons beyond the developer's control. So we can reasonably leave maybe another 3 to 4 months from that date. But if the delay goes on and on for over 1 year, then it's a serious issue.
Yes.
Because we are talking about a purchaser who may have parted with, let's say, 30-40 million, sometimes for big, luxury condominiums, or even a middle income earner. It's a lot of money if it's 5 or 6 million rupees. So that person has to wait, and if he has taken a loan, he has to continue paying interest on that loan. So it's a serious issue. So therefore, I would suggest anyone who wants to purchase a condominium unit should request the developer that if there is a delay beyond a reasonable period of 3 to 4 months, then the developer should pay a reasonable interest for the money that he is holding. So that is something that people should request from developers.
Thank you so much, Ms. Edriman. Unfortunately, that is all we have time for, but fear not, viewer, we are going to have Ms. Ajita Edriman with us next week as well when we continue on this topic of apartment ownership. So make sure that you are back in your seats in front of your TV next Friday at the same time, where we follow up on this discussion on vertical living. Good night.